considered the act also. It's not that they
after considering whether Article 21A is valid.
No. How do they uphold Article 21A?
Not by looking at the act.
They say it does not take away the right of the minorities to administer and schools.
No.
Just turn to sub-paraphrase.
Yes.
Keep on what you read just now.
All right.
You read it just now?
Yes. Under Article 30.
No, just come to above para 55.
Yes.
That's sub-para. Just read it.
Thus, the power under Article 21A of the Constitution, vesting in the state, cannot extend to making any law which will abrogate the right of minorities to establish.
So that law would be invalidated.
The law would be invalidated.
Not Article 21.
That's right. So to save this, they have done this.
21A could not have been declared ultra-vires.
Miller,
Only the law, if it abrogates.
I'll go one step further, Miller. I'll go one step further. You could have declared Article 21A to be violative of the basic structure. Then 21A would have vanished. What would have gone is the Amendment Act. Then the question of deciding whether this act is or is not violative of Article 30 would not have arisen, because 21A doesn't exist then.
Yes, the basic thing could have also gone. There are three options over.
Yes.
One is Article 21A is struck down.
Yes.
The other is Article 21 is upheld.
Yes.
And the
Law is struck down.
No, law is also not struck down. Law is also upheld.
Law is also.
Another option is Article 21 is upheld and the law is held to be not applicable to minorities.
Miller, the validity of 21A cannot depend upon the legislation. Just cannot.
No, you're right. No issue on that.
So by saving,
Then you're right.
so therefore by construing the legislation in a particular fashion, you cannot save 21.
No. What they're saving 21A is by interpreting 21A. They're interpreting 21A to mean that it cannot trample upon the rights of the minorities. I hope I'm making myself clear.
Yes, it cannot.
It cannot trample upon the rights.
Because Miller, yes, Miller, correct. Right? Cannot trample.
It cannot trample.
Correct.
So that's the interpretation they give, and they say it's perfectly valid.
Yes.
Now, once they hold that it cannot trample upon the rights of the minorities,
Yes.
they have said that this act does not apply to minorities.
Miller,
That's how the Constitution bench seems to have gone about it, in broad terms.
but Miller,
This act is an extremely broad act.
no, I'm not
It
at all.
is not just confined to 25%.
Miller, then Miller, the source of this legislation will go.
No, not the source. Source is
The
perfect.
source is 21A.
Source is fine. But only question is will it apply to minority institutions or not?
That's a different question. And when you answer that question, Miller, it will take away the legislation, not 21A.
Correct.
So if for instance,
But they have held.
all right, Miller, I'll try to answer it in a different way. Suppose it was found that this legislation did apply. Let us assume. Suppose, Miller, the section had read expressly that in minority institutions as well, Section 23 would apply. So let us say that there is no getting away from the fact
Correct.
that this legislation is applicable to minority institutions. That would have no bearing, my lord, on whether Article 21A is violative of the basic structure.
Correct. But
Because 21,
no, you're right. Absolutely right.
Yeah.
While dealing with this issue, they have interpreted Article 21A also. They have put some limits on 21A while upholding it.
no,
The limit is it does not trample upon. It cannot deal with minority.
that is because of the general principle. That is because of the general principle that no article can trample upon, let us say, 14.
So therefore, if it is saying it does not deal with minorities,
Yes.
that's how they uphold it. The argument was that Article 21A is unconstitutional because it deals with minority institutions. They said no, it does not deal with minority institutions. They put the minority institutions outside the act.
Well, there is no proposition that Article 21A is violative of the basic structure because it deals with minority institutions.
That must be the argument.
No.
See how his canvas will deal with it.
Yes, all right. Very
You
well.
will find that judgment. Is there any paragraph that Article 21A has been read down?
59 of that Societies Act 2000.
No, in this judgment, in commonly has it been read down?
No.
In clear judgment, it has been specifically what not says that has been framed.
Reading down is an avenue open for a court to save a statutory provision from being struck down. If there is no reading down, court does not revert to reading down, then of course the validity of 21A may not have been in doubt. What happens is if the law abrogates,
this part. No, again,
Your Lordship is raising a question, my Lord. I think the answer will lie in going into this judgment in some later date.
Right.
No doubt.
You have to go.
No doubt. It is not just 54 and 55 which has to be looked into. But I found it. Let's do that.
and you will have to go back to the society also.
Yes.
The judgment, three judges from
Yes.
the reference of those.
Yes.
Because there are certain paragraphs in that judgment.
Yes.
I think Justice Swatantra and the chief were on one side, Justice Kapadia, and
Justice Radhakrishnan.
Radhakrishnan, to a certain extent,
Yes.
was on the other side.
Correct.
So you will have to examine that, and there are some observations which came in over there.
All right. Very well. No question.
Examine that primary judgment,
Yes.
then come to this. Because see,
We
when
can
I'm
do
dealing with this act, Mr. Gupta, while dealing with this act with
Yes.
the High Court,
Yes.
I have heard that you have to provide computers to all children in
Yes.
schools,
Yes. Yes.
ensuring that there is no.
No. It's a very wide legislation.
It's a very right legislation.
Yes.
I have read some rules and some acts, provisions, and then try to create a situation.
Correct.
So it's extremely broad. This act is extremely wide.
It
It's just confined to 25%. That is one of its hallmarks.
No. I agree. It's not confined to 25%, but no doubt. I'm saying, my Lord, section 12 is confined to 25%. That is the section which was found to be offensive.
Correct.
To Article 30.
Correct.
It is not violative of Article 21. Because Article 21A, my Lord, only permits this legislation to be made. If it was violative of the basic structure, then 21A should be taken out of the statute books altogether. And that, my Lord, subject to correction, my Lord, cannot be saved by reading down any legislation or even reading down a 21A, because it actually violates the basic structure. But anyway, my Lord, let us look at the judgment, my Lord, for that purpose. If your Lordship sees para 3, first of all, how did this question arise? The question was, my Lord, arising out of the judgment of Ashok Kumar Thakur. Para 3, 243. Page 2. Give it to the court. Give the citation. Well, the first and most important aspect which was raised as far as 15.5 is concerned is para 3. The Constitution, Lordship has don't give that judgment yet. I'm still on this one. Willard, that 3-judge bench judgment is not in the compilation, Willard. Therefore, I've given your Lordship's officers, Willard, the book. We'll take it up, Willard, in a few minutes. The constitutional validity of clause 5 of Article 15 of the Constitution, insofar as it enables the state to make special provisions relating to admission to educational institutions of the state and educational institutions aided by the state, was considered by the Constitution in Ashok Kumar Thakur, and the Constitution held in the aforesaid case that clause 5 of Article 15 is valid and does not violate the basic structure of the Constitution so far as it relates to the state-maintained institutions and aided educational institutions. In the aforesaid case, however, the Constitution bench left open the question whether Article 15 of Clause 5 of Article 15 was constitutionally valid or not, so far as private unaided educational institutions were concerned. As such, private unaided educational institutions were not before the court. This batch of writ petitions has been filed by private unaided educational institutions, and we are called upon to decide whether Clause 5 of Article 15 of the Constitution, so far as it relates to private unaided educational institutions, is valid and does not violate the basic structure of the Constitution. Your Lordship may note, my Lord, that Justice Bhandari delivered a separate judgment, a concurring judgment according to him, on the principal issue. But he also decided, my Lord, on the private unaided educational institutions and said that if we were to consider private unaided educational institutions, in that case, it might be unconstitutional. So, my Lord, this here, but without success. So then Article 21 is set out, and but before that, your lordship should take 15.5 also. Look at 15.5. Kindly take 15.5 in the Constitution.
Yes, it's quoted.
Yes. Nothing in this article or in subclause G of clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes or the scheduled tribes, insofar as such special provision relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of Article 30. Clause 15 therefore enables the state to make special provision. So therefore, my lord, that was the first aspect. The second aspect was 21A. Now, kindly see, my lord, the opinion of the court in respect of 15.5 and the opinion of the court in respect of 21A. The opinion on 15.5, my lord, starts with para 21.
Just for completeness,
Yes.
read page 244, 5.1 and 5.2, the two questions.
Yes, I'll place that again. Whether by inserting clause 5 of Article 15 of the Constitution by the 93rd Amendment Act, Parliament has altered the basic structure or framework of the Constitution. But actually the question is slightly awkwardly positioned.
Has there been any decision of our court
Yes.
that
Can
one fundamental right is ultra-vires another fundamental right?
Sorry, Miller?
One fundamental right
Yes.
is ultra-vires another fundamental
No,
right.
the question would not arise.
So
Question.
this is what they are considering.
No.
What is basic structure?
No.
What are basic structure? We say basic structure, basic structure.
Yes.
What is basic structure? Sometimes we interchangeably use basic features,
Yes.
right? Our structure is, it's a republic, it's a democracy, parliamentary form of government, independence of judiciary. These are what constitute a basic structure.
Right.
But these are all features.
Yes.
Therefore, to say that a fundamental right is violating of the basic structure, fundamentally the question is wrong. Hearing of the question is wrong.
No, but this is an amendment.
You have to ensure there is a presumption of constitutionality so far as statutes are concerned. For a fundamental right, it would be on a very high pedestal.
True, but here,
Therefore,
yes.
to pitch it that high that a one fundamental right is destroying another fundamental right.
No, Millard, it would have
Out a very good.
Millard, but for the fact that it is by an amendment to the fundamental right which is being considered. Now, it is possible today,
But
Millard.
it's a fundamental right.
Yes.
By amendment of the constitution, one fundamental right has been amended, 15.5 has been inserted,
Yes.
and a new fundamental right created.
That's right,
If
Millard.
we go by the narrow theory,
Yes.
then there cannot be any addition of fundamental right apart from whatever is there.
No, so therefore, Millard, the question is, how far can the amending power be taken? And the amending power can be taken as far as the basic structure is concerned. Beyond the basic structure, you cannot amend.
So I am minded to say like this.
Yes.
If you consider the human body
Yes.
as having a structure, what is your basic structure?
Yes.
You have this head, you have this torso, you have these hands, you have feet. So you cannot put wings here to fly. That would be changing the basic structure. But that you are wearing glasses,
That we can.
that is rubbish.
Yes, that is correct. Now, Millard, what I am saying about the question is a little different. Reason why I think, Millard, this question might have been framed better is because it seems to suggest the court is inquiring whether a particular amendment has in fact altered the basic structure. That question doesn't arise. If it had, then the Amendment Act would have to be struck down because it is beyond the amending power of the Parliament. Anyway, let us read this question 5.1 and 5.2 to mean whether by inserting these two clauses by way of two amendment acts, the basic structure or framework of the constitution has been affected, in which case these two amendment acts must be struck down. You cannot introduce 15.5, you cannot introduce 21A, 21 capital. Now, let us, would your lordship like to look at the opinion on how this is decided? The decision as far as 15.5 is concerned starts from para 21. Well, 15.5 is perhaps less critical here than 21A, but nonetheless, my lord, since your lordships are going into
15.5 may not be there because 15.5 explicitly excludes the minority institutions.
yes,
So therefore it may not arise.
correct. But see, my lord, now take the judgment as a whole, my lord, because your lordships are looking at it as a whole.
15.5 included aided. So there can be a minority which is aided. So that is why
The Constitution makes it says that fundamental rights are not in any hierarchy. Somewhere I've read, I don't remember somewhere it's there. Anyway, we'll find it.
But there is no hierarchy.
There's no hierarchy.
There's
They
no
have to
hierarchy.
accommodate each other.
Yes. And my lord, it is also, my lord, that you have to read them
Yes.
together.
Yes. Read them.
Yes.
That's right. Yes.
you just find para 7
Yes.
at 245.
Yes. Mr. Rohatgi explained that a 9-judge bench of this court in Coelho, relying on Minerva Mills, has similarly held that Articles 14, 19, and 21 of the Constitution stand on altogether a different footing, and after the evolution of basic structure doctrine, it will not be open to immunize legislation made by Parliament from judicial scrutiny on the ground that these fundamental rights are not part of the basic structure of the Constitution. He
Therefore,
submitted.
14, 19, 21 may,
No, so they have been
at the time of it,
Yeah.
may have.
So the hierarchy will only be this, my lord. That is it part of the basic structure or not? That's all. It cannot be anything else.
Fundamental rights are part of basic structure.
Not all of them. My lord, your lordship said very early on that we are not going to define what is in basic structure, and we are also not going to say that every fundamental right is part of the basic structure. But by now, my lord, it is clear that 14, 19, 21 will be, because to take any of those away would go to the basis of the. And my lord, here also we are finding the paragraph of Justice Sikri which said that 30 also would be part of the basic structure. Very well. Now, my lord, one by one, my lord, under Article 15.5, my lord, it was considered whether they violate any of the fundamental rights which are part of the basic structure, 14, 19, 21, etc. And comes to the conclusion at paragraph 38. Please see, my lord, at page 261. We accordingly hold that none of the rights under Article 14, 19.1g and 21 of the Constitution have been abrogated by Clause 5 of Article 15 of the Constitution, and the just view taken by Justice Bhandari that the imposition of reservation on unaided institutions by the 93rd Amendment was abrogating Article 19(1)(g), a basic feature of the Constitution, is not correct. Instead, we hold that the Constitution 93rd Amendment Act inserting Clause 5 is constitutionally valid. As your Lordship said, my Lord, Article 30 issue is not relevant as far as Article 15(5) is concerned. So, my Lord, the discussion of 14, 19 and 21 takes place without reference to minority institutions. Justice Bhandari's concurring judgment in Ashok Kumar Thakur that if you had imposed reservation on unaided institutions, then it might have abrogated the 19(1)(g). That was not upheld by this court, my Lord, considered and rejected. So therefore, my Lord, that was, my Lord, as far as 15 is concerned. Now see, my Lord, the validity of 21 is finally discussed in paragraph 48 onwards. Since your Lordship, my Lord, is looking into this aspect, my Lord, then please allow me to, my Lord, place this portion 48 onwards. Page is, my Lord, 265. Opinion of the court in Article 21A of the Constitution on the validity of the 2009 Act. We have considered the submission of the learned counsel for the parties, and we find that this is what is stated in the statement of objects and reasons of Constitution 83rd Amendment Bill, which ultimately was enacted. The Constitution of India, in a directive principle contained in Article 45, has made provision for free and compulsory education for all children up to the age of 14 years within 10 years of promulgation of the Constitution. We could not achieve this goal even after 50 years of adoption of this provision. The task of providing education to all children in this age group gained momentum after the National Policy of Education was announced in '86. The Government of India, in partnership with state government, has made strenuous efforts to fulfill this mandate, and though significant improvements are seen in various education indicators, ultimate goal of providing universal quality education still remains unfulfilled. In order to fulfill this goal, it is felt that an explicit provision should be made in the part relating to fundamental rights of the Constitution. So, we are taking one directive principle and putting it into the fundamental rights chapter. With a view to making free and compulsory education a fundamental right, the Constitution 83rd Amendment Bill was introduced in Parliament to insert a new article, namely 21A, conferring on all children in the age group of 6 to 14 the right to free and compulsory education. The said bill was scrutinized by the Parliamentary Standing Committee. Subject was dealt with in the Law Commission. After taking into consideration the reports, etc., the proposed amendments were being made, which is as follows: to provide free and compulsory education to children in the age group 6 to 14, and for this purpose, a legislation to be introduced in Parliament after the Constitution bill is enacted, etc. Now, it will thus be clear from the statement of objects and reasons extracted above that although the directive principles in Article 45 contemplated that the state would provide free and compulsory education to all children up to the age of 14 years, within 10 years of promulgation of the Constitution, this goal could not be achieved even after 50 years, and therefore a constitutional amendment was proposed to be inserted, 21A, into the Constitution. Bearing in mind this object of the Constitution, inserting 21A, we may now proceed to consider the submissions of the learned counsel. So the objects of introduction of 21A is gone. Article 21A, as we have noticed, states that the state shall provide free education, etc. The word state can only mean state which can make law. Hence, Mr. Rourke and Mr. Nariman are right in their submissions that the constitutional obligation under 21A of the Constitution is on the state to provide free and compulsory education to all children of the age so-and-so, and not on private unaided educational institutions. 21A, however, states that the state shall by law determine the manner in which it will discharge the constitutional obligation. Thus, a new power was vested in the state to enable the state to discharge this constitutional obligation by making a law. However, Article 21A has to be harmoniously construed with Article 19(1)(g) and 30 of the Constitution. It has been held in this court in Venkatrama Devaru. The rule of construction, then the harmonious rule, is spoken of. We do not find anything in Article 21A which conflicts with either the right of private unaided schools under Article 19(1)(g) or the right of minority schools under Article 30 of the Constitution. But the law made under 21A may affect these rights under 19(1)(g) and 30. The law made by the state to provide free and compulsory education to the children should not therefore be such as to abrogate the right of unaided private educational schools under 19(1)(g) or 30. So, my lord, without this statement is made without reference to any particular statute. Every statute which is made under 21A will have to be considered to see whether they go and violate 19(1)(g) or 30. Undoubtedly. But what is in contemplation is that 21A has not violated 19(1)(g) or 30. A law might. A law made under it might. So the amendment is not bad. While discussing the validity, para 50, while discussing the validity of clause 5 of article 50, we have already noticed that in para 53 and 68 of TMFI Foundation, this court has held that the admission of a small percentage of students belonging to weaker section, if not granted by the government, and the admission of some seats to take care of poorer and backward society, may be permissible and would not be inconsistent with the rights under 19(1)(g) of the Constitution. In Amdar, however, this court explained that there was nothing in this court's judgment in TMFI Foundation to say that such admission of students from weaker, backward, and poorer sections in private and unaided institutions can be done by the state, because the power vested in the state in clause 6 of 19 of the Constitution is to make only regulatory provisions, and this power could not be used by the state to force admissions from amongst weaker, backward, and poorer sections of the society on private unaided institutions. While discussing the validity of clause 5, we have also held that there is an element of voluntariness in all the freedoms under 19(1) of the Constitution, but the voluntariness in these freedoms can be exercised, can be subjected to law made under the powers available under 19(2) to 6. In our considered opinion, therefore, by the Constitution 86th Amendment Act, a new power was made available to the state under Article 21A to make a law determining the manner in which it will provide free and compulsory education to the children of the age of 6 to 14 years, as this goal contemplated in the directive principles before this amendment would not be achieved. This additional power vested by the Constitution in the state is independent and different from the power of the state under clause 9 of Article 19 and has affected the voluntariness of the right under 19(1)(g) of the Constitution. By exercising this additional power, state can by law impose admission on private unaided schools, and so long as the law made by the state in exercise of this power under 21A is for the purpose of providing free and compulsory education, and so long as such law forces admission of children of poorer and weaker sections to a small percentage to achieve the constitutional goal set out in the preamble, such a law would not be destructive of the right of the private unaided education institution under 19(1)(g). To give an idea of the goals Parliament intended to achieve by enacting the 2009 Law Act, we extract paragraphs 4, 5, and 6 of the Statement of Objects and Reasons. The proposed legislation is anchored in the belief that the values of equality, social justice, democracy, and creation of just, humane society can be achieved only through provision of inclusivity. Actually, in my respectful submission, my lord, up to this point, my lord, the validity of the amendment which brings in 21A is under consideration. That is done, my lord, without reference to the law to be enacted under it. Has to be, my lord, because the law is not there. Once the 21A has to survive and stand up on its own, then the question comes, what is the law? Then, my lord, 52 onwards, they are discussing this particular act, 2009 Act. The proposed legislation is anchored in the belief that the values of equality, etc., and the creation of a just, humane society can be achieved only through provision of inclusive elementary education to all, provision of free and compulsory education of satisfactory quality to children from disadvantaged and weaker section is therefore not merely the responsibility of schools run or supported by appropriate governments, but also of schools which are not dependent on government funds. So unaided also. It is therefore expedient and necessary to enact a suitable legislation as envisaged. It will be clear from the aforesaid extract that the 2009 Act intended to achieve the constitutional goal of equality of opportunity through inclusive elementary education to all, and also also intend that the private schools which did not receive government aid should also take the responsibility of providing free and compulsory education of satisfactory quality of children from disadvantaged and weaker sections. When we examine the 2009 Act, we find under section 12(1)(c), read with 2(n), an unaided school not receiving any kind of aid or grant to meet its expenses from the appropriate government or local authority is required to admit in class 1 to the extent of at least 25% of the strength of that class children belonging to weaker section and disadvantaged groups, and provide till its completion. We find further that under 12(2), such a school shall be reimbursed expenditure so incurred by it to the extent of per child expenditure incurred by the state or the actual amount charged from the child, whichever is less, in such manner as may be prescribed. Thus, ultimately, it is the state which is funding the expenses of free and compulsory education of the children belonging to these sections, which are admitted to a private unaided school. These provisions of the 2009 Act, in our view, are for the purpose of providing free and compulsory education, etc., and are consistent with the right under Article 19(1)(g) of the Constitution as interpreted in TMFI Foundation, and are meant to achieve the constitutional goals. We therefore do not find any merit in the submission made on behalf of the non-minority private school that 21A of the Constitution and the 2009 Act violate their right under 19(1)(g). So up to here also, we are not dealing with 30 in its relation to 2009 Act. Then we come to 30. Under 31, all minorities which are based on religion and language shall have the right to establish and administer. But I have placed these two paragraphs, but it's not necessary to place it again. What it says very simply is 12(1) read with 2(n) violates Article 30. Now, your Lordship will notice, my Lord, that in order to strike down or in order to hold that the entirety of the legislation is violative of Article 30, the court would have to go into the exercise of considering section by section what are the various obligations created by this legislation, and are each of these obligations violative of Article 30. Because, my Lord, your Lordships have laid it down time and again that you will only interfere with the legislation to the extent that it is necessary. So you can apply the blue pencil theory, you can delete a particular provision if that is necessary. Now, if 12 is offending, you will not strike down the whole legislation. And the only grievance is that 12 violates Article 30. Why? Because it forces admission of students in a manner contrary to the right of the minority. If that is so, Lord, to say that I will strike down the entirety of the legislation because of this, Lord, that would not make much sense, Lord, because it is perfectly open to the court to say that I strike down 12, I leave everything else in the statute books. It is not as if, Lord, these are inseparable sections. The question of teacher training and the question of admission of students are two completely different aspects. Now, if admission of appointment of teachers is also such as to violate minority rights, Lord, in that event, Lord, the court would have said so. Now, perhaps, Lord, your Lordship may even today will not consider that question. Even if you come to the conclusion that Pramati Educational does not strike down the entirety of the legislation, it only strikes down section 12. Somebody may stand up and argue before your Lordship, but then now decide whether 23 does or does not. So, my Lord, there are two submissions, my Lord, in my respectful submission. Response to your Lordship's query.